You don't have to worry about Rule 60. I'm not granting them any Rule 60 relief. It's, I don't have jurisdiction to do that. That would be an instant reversal.
All right. Purpose 16 is now in session. Back.
All right, thank you, man. And good morning, everyone. I just want to welcome you to our Wednesday, June 12th, 2024, 9 o'clock a.m. law and motion calendar. And we're going to proceed in case order set forth on the calendar. We're going to call the uncontested matters first to get you out of here. Then we'll go to the contested matters. Next up, page 10, is that right? Okay, we're going to move on. Next up, page 10 of the calendar, Hunter Biden versus Affinity Lifestyles. Let's go ahead and set forth our appearances. Pardon? I'm sorry, Hunter Brown versus Affinity Lifestyles.
Good morning, Your Honor. This is Brianna Switzler on behalf of Plaintiff Hunter Brown and all the plaintiffs.
Good morning, Your Honor. Joel Odou on behalf of the Real Water defendants.
Jon Carlston on behalf of defendant Nevada Beverage Co.
Good morning.
Jack Burden, Your Honor, on behalf of Albertsons LLC and SFM LLC defendants.
Good morning, Mr. Burden. Haven't seen you for a while.
Yeah, good morning, Your Honor.
And Your Honor, Jim Neal on behalf of UNFW and Whole Foods.
Good morning, Mr. Neal. And does that cover all appearances?
Good morning, Your Honor. This is Mishancy Kramer here for Kihi.
And good morning. All right, and I think we have one matter on calendar this morning, and it appears to be a plaintiff's motion for a preferential trial setting. Is that correct?
That is correct, Your Honor.
And I remember we've had discussion regarding this matter, and it was moved from the April 24th, 2024 hearing to today because we wanted to make sure we were in compliance with the statutory mandate. Right?
That is correct, Your Honor.
Okay, and it's my recollection that the plaintiff in this case is in excess 70 years or older. Is that correct, ma'am?
That is correct.
And statutorily, they have a right to a preferential trial setting under Nevada law.
Yes,
Correct?
that is correct.
Any need for discussion?
We don't believe so, Your Honor. As you mentioned, we moved this just to be in compliance with the rule, and so it's just doing our due diligence here for today.
I understand. Now, anything from the defense?
Not from Real Water, Your Honor. Thank you.
Anyone else want to jump in? I just want to make sure.
You're
All
right.
From UNFW, Your Honor.
Okay. All right. Well, what am I? Yes.
Sorry, Jon Carlston, Nevada Beverage Co. Just for the record, that the argument that has been advanced that yes, Miss Brown qualifies. However, just for the record, the majority of the other plaintiffs obviously are not, and so the concern is that this statute is being abused in terms of taking all of the plaintiffs to this preferential trial setting in this consolidated action, but nothing further, Your Honor.
Oh, I understand, sir. And of course, you have a right to set forth your concerns on the record. I respect that.
Thank you, Your Honor.
And you're welcome, sir. And in light of the current procedural posture of this matter, and I do realize we have consolidated cases in the real water matters, notwithstanding that, based upon the fact that the plaintiff making this request is 70 years or older under Nevada law, statutorily, they get a preferential trial setting. And so what I'm going to do, I'll go ahead and grant the motion. And ma'am, can you prepare the appropriate order?
We will, Your Honor.
Okay, everyone enjoy your day.
Thank
Thank you,
you.
Your Honor.
All right, I just want to say good afternoon to everyone and welcome you to the 2 o'clock Wednesday, June 12th, Hunter versus Brown law and motion calendar special session. Let's go ahead and set forth our appearances on the record. We'll start first with the plaintiff, then we'll move to the defense.
Good afternoon, Your Honor. This is Brianna Switzler on behalf of plaintiffs.
Good afternoon, Your Honor. Michael Gayan, also be on behalf of plaintiffs. Good afternoon, Your Honor. Jonathan Fountain on behalf of defendant NSF International.
Hello, Your Honor. Jim Neal on behalf of UNFW and Whole Foods.
All right.
Good afternoon, Jon Carlston on behalf of Nevada Beverage Co.
Good afternoon, Jan Tomask for defendant ETT1.
Good afternoon, Machancy Kramer for Kihi.
Good afternoon, Duncan Justice on behalf of Costco Wholesale Corporation.
Good afternoon, Sebastian Krabari, also on behalf of Costco.
Is that everyone? Okay, once again, good afternoon, everyone. I think we had one matter on calendar. It's plaintiff Daisy Wee's motion for relief from judgment pursuant to 60B. Basically, it's requesting a honeycut decision. I understand what's going on. Not necessarily seeking relief from the because I mean I don't have jurisdiction right now. I get it. Let's go ahead and get started. Ma'am.
Good afternoon, Your Honor. So as you mentioned, this is a honeycut type motion. So we're asking for a indicative kind of ruling as far as this goes. Just to provide a little bit of context to the motion, plaintiff Daisy Wee filed an amended complaint making allegations against NSF for negligence stemming from their investigations into real water. In the 5 cases where we amended the complaints, NSF filed motions to dismiss with 4 out of the 5 judges denying the motion to dismiss. Judge Johnson granted NSF's motion, determining that more factual allegations were necessary to state a claim for relief. In her order, Judge Johnson recognized that there were potential facts available, but just that we didn't have them at the time. There was a subsequent motion for reconsideration and alternative request for leave to amend, which was also denied. So plaintiffs filed an appeal as it relates to that. We then the decision in that order was not finalized pursuant to 54 until December of 2023. In February, plaintiffs filed their motion to consolidate, which this court granted in March. Plaintiffs deposed Robin Forgy, Costco's Director of Food Safety and Quality Assurance, about a week after that. And that's kind of really where this motion comes in here. At this deposition, Forgy testified that the Costco procedure was violated when NSF allowed Real Water to pick lenient auditors instead of the ones who kind of called out their quality control issues. This factual evidence of duty and breach was not available to Judge Johnson when she made her decision. And that's why we're here today. While typically, as you mentioned, on appeal, the court is divested of jurisdiction, there is this procedure which allows to certify a result and an intent to grant the motion if it sees fit. The motion request for the indicative ruling, it really hinges on these additional factual considerations that kind of came up after Judge Johnson made her request. And that's kind of where we're here is the person, an entity that requested the audit from NSF and used that as a barometer to whether or not to sell the Real Water, testified that that their procedures were violated when NSF did this. And that's kind of what brings us here. And that's clear indication of duty and causation. And kind of to get something out of this motion is timely. Rule 60B2 provides a 6-month time frame when you're alleging new facts as to a request for a new trial. We're not here seeking requests for a new trial. We're here in this little bit. Miss Wee never had a trial. Her claims were dismissed under 12B5. So we're here trying to make sure that her claims be heard on the merit. So we're kind of in this zone of 60B6, which is a reasonable time. It's clear that we're reasonable time. In fact, even if you're looking at a 6-month timeline, the motion was filed well within the 6-month time period after the certification of finality. And as we mentioned in our reply, which I know was filed later last night, Rule 60 is intended to read broadly and gives this court a lot of discretion with, the focus is the public policy on hearing a case on its merits. And that wasn't what happened here. Is we have these new facts and circumstances that clearly indicate a duty and causation and a breach of that duty that led to Miss Wee's hospitalization that wasn't able to be addressed before the 12B5 dismissal. And again, Ms. Foji is Costco's Director of Food Safety and Quality Assurance. So her testimony shows that NSF had a legal duty to perform Costco audits to a minimum standard of care. NSF violated those standards of care by allowing Real Water to choose its auditors. And that violation undermined the entire integrity and the purpose of the audit, which is ensuring a safe product that ultimately got into the hands of Daisy Wee, which was toxic and caused her hospitalization. And you almost know that the 60B relief is warranted and there's new facts when NSF's motion kind of addresses and talks about all the factual.
Aren't we really talking about a Rule 62.1 issue here, right? As far as, and the reason why I'm bringing that up, and that's the honeycut procedure that specifically deals with, and I realize I'm divested of jurisdiction, but when I know we keep bringing up Rule 60, I don't see it as a Rule 60 issue. And I'm looking at it through this lens because we do have the honeycut case, right?
Mm-hmm.
And under certain circumstances, you can move and request an indicative ruling on motions for relief that are barred by a pending appeal. That's a different issue, right?
Correct. So this court has jurisdiction to kind of certify its, as we kind of stated in, I believe, in the motion under subsection C, the court has jurisdiction to hear the plaintiff's motion to certify its intent to grant 60B relief. So what's happened is Judge Johnson's order dismissing the claims under 12B5 are up on appeal. Our understanding is the process outlined.
I have a question about that because when it comes to pleading negligence cases, unless there's fraud involved, there's no particularity requirement, right? And I do understand what the issues are, but there's no requirement of particularity. And as far as duty, I mean, you can plead that generally, right? And I want to hear some discussion on this because it appeared to me that this jumped off the page. Potentially, you had a restatement of torts 324A issue involving a voluntary undertaking.
Correct.
And I know you cited cases. There's other cases out there. It's actually discussed in fairly significant detail in Wright versus Shum.
Correct, Your Honor. And that's the basis of plaintiff's appeal of Judge Johnson's initial 12B5 is we believe that we've stated with particularity the facts and allegations, but even in
But
addition.
what I'm saying is, unless it's fraud or mistake under 9B, there's no particularity requirement. All you have to do is get sufficient facts. That's all. You know, and you either there is a duty or there's not, but it's unless it's so patently obvious, you don't grant 12B5 motions as it pertains to duty. I mean, there's certain circumstances, and I've granted them where, for example, you see the wrong person or something like that, right? You know?
Yeah, and we definitely agree with Your Honor as that respect. And Judge Johnson in her order granted 12B5 and arguing that the plaintiffs needed to allege more specific facts and said that there is not enough factual content alleged in the first amended complaint for this court to infer a negligent audit or inspection. So that's kind of what brings us here today is the complaint was dismissed. We now have more facts, thereby being the Costco deposition that happened, which said Costco policy was violated because of NSF's conduct, which gives rise to new facts and circumstances that Judge Johnson.
When you say their policy was violated, specifically for the record, what do you mean by that?
Correct. So I'm just going to read for.
And that's okay, ma'am. Take your time.
Yeah, on page 10 of our motion, I believe it's also on page 6 of our reply. I don't know which one you have handy,
I have both.
We actually have the testimony there. And so the question asked in the deposition was, under Costco's requirements, would Real Water be allowed to pick their own auditor from NSF? The response, if we skip down a line, says they don't get to choose who the person is they send to do the audit. Basically, they're allowed to choose the auditing company, NSF, but not allowed to pick the specific auditor. And so the question then is, and what is the reason that they don't get to choose integrity of the audit? Yes. So if NSF was letting Real Water pick and choose who they wanted to audit the facility, that would not be in conformance of what Costco expected. Correct. And that is the new facts and testimony that we received about on March 25th, I believe, Your Honor, that we believe gives us rise to request for 60B relief from Judge Johnson's order dismissing our claim under 12B5. And as far as looking under Rule 62, as far as the indicative motion and the honeycut procedure, if we look at 62.1, and it's on page 15 of our motion, if that helps too, Your Honor. If you look at A3, if the motion is made, the district court needs to state either that it would grant the motion if the appellate court remands for the purpose, or that the motion raises a substantial issue. So that's kind of what we're looking and requesting for today is, obviously this court is divested of jurisdiction to actually grant the Rule 60B relief, but we can state either that you'd grant the motion if the appellate court were to remand it back to you, or at least that it raises a substantial issue. And based on what we have brought here today, we believe that there are one of those two things based on the new facts and circumstances here.
Anything else, man?
Yes, just to address, just to address a couple other quick little things, Your Honor, is, as I stated, the opposition spends 4 or 5 pages kind of looking at different interpretations of the facts, and we think that kind of supports our request. And the reason why we're here today is because clearly there is, especially with these new factual circumstances, there is a basis for plaintiffs to state a claim. And so really this kind of boils down to is NSF has alleged that there's some sort of prejudice in this motion, and plaintiffs believes that there is no prejudice. And NSF is really not indicated with any clear specificity as to what they would be prejudiced for. NSF has participated in discovery in the coordinated rail water cases. As this judge is probably familiar, we had coordinated discovery in all the rail water cases. So NSF participated and had access to all the documents in the underlying cases. Something else is they also filed experts already. In fact, they've already filed experts in the Hunwartson claim on this issue, requested by the same attorneys, talking about the NSF policies and procedures. And that expert has already been deposed. So as far as there's not a lot of prejudice there when the clear claims are very similar. And, you know, we still have 2 months left in the discovery period. So we believe that there's not really a prejudice there, but the prejudice comes from, and really is for plaintiff Daisy Wee. Right now, Daisy Wee has to wait on appeal for potentially months. And
Should I even be considering prejudice when it comes to this specific issue? Right? I mean, really and truly, because I'm not deciding anything. It's a honeycut request,
correct.
right?
Yes, Your Honor. And like I said,
It really is. I mean, what happens is this, I mean, either the Supreme Court's going to affirm and or remand, right? Reverse or remand. That's what's going to happen. So, I mean, we're talking about prejudice. I don't even see where prejudice is an issue, it specifically as it relates to the application of 62.1.
Correct. And the prejudice is, you know, if you certify your request, or if you state that you'd grant the motion, or at least say that there's substantial issues, NSF has argued if they're somehow catapulted back into this case, they would suffer prejudice. And so that's why I just want to.
There's no prejudice if they should be in the case.
That's plaintiff's understanding as well, is that.
I mean, really, either the complaint was correctly drafted and or there should have been an opportunity to amend or not. Right? And that's a procedural issue. And then Nevada is a notice pleading state, as we all know, right?
Correct.
And there's no particularity requirement for negligence claims.
Yes, Your Honor. And that's why we believe that this relief is requested and that we should be able to, and that's why we have indicated our requested relief, which is for Your Honor to, under 62A, to certify that you would grant the motion and or that there was, substantial issues that you would consider this motion would it had it be remanded back to you. And so with that, I'll save any additional time for rebuttal and see, unless your honor has any other
I don't have any
questions.
questions. Thank you, ma'am. We'll hear from the opposition.
Good afternoon, Your Honor.
Good afternoon.
We don't believe the motion is timely or presents a substantial issue.
And why is that?
Well,
And I want to really talk about the law.
you bet.
And here's the point. It appears to me that what NSF has done in this case, and we have the restatement of torts 324A, and it deals specifically with voluntary undertakings. Now, hypothetically, if they weren't doing any audits, there would be no duty at all. But once they undertake that responsibility, they have to do it, based upon standards of reasonable care. That's really what it comes down to, right?
I appreciate that, Your Honor. The problem in this case is that the complaint was threadbare. There were very few, and I mean very few facts, and I understand the court's point about, well, you don't have to plead negligence with particularity.
You don't.
But this isn't an ordinary negligence claim. It's not a first-party negligence claim. They're trying to hold a third-party auditing company.
No,
liable.
why can't it be first party? And here's my point. Yeah, they might not be responsible until they conduct the audit or they start going through the audit procedures. And here's my point. I remember the exact same issue was raised in the cases involving Dr. Desai and Southwest Medical Center. And this exact same issue came up where Southwest Medical Center said, wait a second here, we're not responsible for Dr. Desai. He was an independent contractor. However, they had a very rigorous credentialing requirement. They had fired Dr. Desai and they brought him back because he was the cheapest guy doing this specific procedure, the endoscopy, right? And I remember we had argument for about 2 hours. And finally, someone mentioned, well, Judge, this was a voluntary undertaking. And that hinged my decision. And you know what? I denied the motion for summary judgment. The case proceeded to trial. The rest is history. There was no reversal. So, and they have a really great discussion on this issue in Wright versus Shum. They do.
And I'm glad,
Probably better than the case that was cited by the plaintiff.
I'm glad you raised that point, Your Honor, because in our briefing, we talked about Dow Chemical versus Malum. We talked about the PetSmart case and we talked about Wright versus Shum.
Right.
In all three cases, the Nevada Supreme Court, and the court said it in Wright. The court said that the defendant, in order for there to be a duty under the Good Samaritan doctrine, that defendant
That wasn't really a Good Samaritan doctrine, was it?
Absolutely, Your Honor.
No, it wasn't. Good Samaritan is different. What happened factually, unless I'm missing something, I haven't read it in a while. And I know Wright versus Shum because the next companion dog bite case after that was my case, Smith versus Harry. But my point is this, the facts are real simple. The landlord had no duty until they went out and started fixing the fence and they assumed the duty.
Until the landlord assumed a duty. That's right, Your
Well,
Honor.
that's what a voluntary undertaking is.
Well, in this case, NSF had no control over the manufacture or distribution of the water. All it did is it goes into the facility, it's audited annually, its auditor fills out a form, and the form gets reported to Real Water and
What does the
Costco.
form say?
And the form,
What does the form say?
well, it's attached to the motion, but it contains a lot of detail about the facility and what the facility is doing and not doing. And the particular audit that occurred in December 2018, NSF actually failed Real Water. It's erroneously alleged in the First Amendment complaint, but NSF actually failed.
What was the
Real Water.
purpose of the audit?
The purpose of the audit was to ensure that Real Water was meeting Costco's audit requirements.
But was it dealing with public safety?
Generally, no.
What do you mean? Either yes, it's like pregnancy, right?
We got a contract.
Really?
Contract, Your Honor. I mean, a contract that limits the scope of the audit, and it says NSF isn't responsible for injuries to third parties. Their job is to come in, look around, and report what they find. That's it. This is $1,500 a year. They don't assume an obligation to protect the entire world from Real Water for $1,500 a year. That's silly.
Well, I mean, well, it all depends on what they're doing. I mean, maybe they should charge more, but if they're going out auditing and if it's dealing with issues regarding safety and sanitary.
The key point is NSF at no time, and it's not alleged, it's alleged nowhere, that NSF alleged any real control over the manufacture or distribution of that product. Now, if NSF had the
But they don't
ability to
have-
pull the plug,
but
it's a
here's the
different
thing.
story.
No, here's the thing. It's not a question necessarily that they were controlling what was going on. It really comes down to what were they communicating regarding what's going on to the entity that hired them as to whether or not they had safe procedures in place at Real Water.
Respectfully, Your Honor, that's a contractual duty that NSF owes to Real Water and Costco as a third-party beneficiary. It's not a duty, it's not a tort duty owed to Ms. Way. And that's why NSF moved to dismiss this case.
Okay, maybe, maybe not. Right?
Well,
I mean, here's my point. The landowner who owned the property had no duty to the public when it came to dog bites until they went out and they did specific task, i.e. issues regarding public safety. They went out, fixed the fence and all those things.
Landlord said he was going to protect the neighborhood in that case.
Well, it's not just what he said, it's what he did.
Yeah. And here we don't have that. We don't have NSF exercising any degree of control over manufacturer distribution. And Wright and Malum and PetSmart all say that that element of control has to be present for a Good Samaritan claim. So it would be error to conclude otherwise. On the timeliness issue, they're citing to a different part of the rule. The rule is pretty clear that the motion's got to be filed 6 months from service of notice of the entry of the order they're seeking relief from. But they point to a different order. They point to an order they didn't appeal. They point to a stipulation for Rule 54B certification where they agreed the order was final and they agreed to expedite the appeal. So my point is they're pointing to the wrong
Explain to
order.
me how this is a Good Samaritan case. I'm trying to figure that out.
It's in our briefing. It's in our briefing below.
I understand that, but I want you to explain it to me.
If I might have a moment, I can point you exactly.
Yeah, I'm trying to figure out how this is a Good Samaritan case. We've had those go to trial too.
We were trying to figure that out too, Your Honor, because they didn't allege it.
But it's not, but my point is, it's not a Good Samaritan case. That's my point. How is it a Good Samaritan case?
It's not,
But you argued that.
because they raised it.
Oh, it's not a Good Samaritan. They're missing it too. I mean, I'm looking right here and I have, Wright versus Shum in front of me. I have purple. It cites the restatement of torts, 324A. So on and so on. Because here it is, straight out of the case. Quote, one who undertakes gratuitously or for consideration to render services to another, which he should recognize as necessary for the protection of third parties or his things, is subject to liability to the third person for physical harm resulting from his failure to exercise reasonable care to protect his undertaking. That's straight out the case. That's the restatement.
I understand what the elements of the doctrine are, Your Honor. They didn't allege the elements. And even in their present motion, they didn't make any attempt to apply the
You don't have
alleged.
to- those aren't elements. I mean, that wasn't argued with particularity. They argued negligence, right? I mean, you look at Wright versus Shum, you argue negligence, and lo and behold, the factual issue comes up, whether there was a voluntary undertaking or not from the landlord.
But Your Honor, we do have pleading standards. They're not non-existent. We have 12B5.
Here's
for a
my
reason.
question. I have a question. Are you saying that you have to allege voluntary undertaking with particularity?
I'm saying they have to put some facts in their complaint that show a voluntary undertaking and that shows the elements of the doctrine to state a legally sufficient claim. That's why we're here, is because Judge Johnson said they didn't state a legally sufficient claim.
You have to allege re ipsa loquitur with particularity.
I think you have to allege the facts and circumstances, Your Honor.
You can know, it's just a form of negligence.
The Nevada Supreme Court said you have to.
That's Camelot Judson versus Camelot Foods.
But the Nevada Supreme Court has said the plaintiff has to allege the nature and basis of their claims. And what that means is the factual nature and factual basis of their claims. Here, the First Amendment complaint contained, it was somewhere around 5 or 6 paragraphs directed at NSF. And they were largely the duty paragraph and causation paragraphs were wholly conclusory.
Go ahead, sir.
So I started talking about the timeliness issue. Does Your Honor want to hear anything on that?
But why is that important in light of this is not a Rule 60?
It's important
Motion.
because
Tell me why.
Rule 12A of the Nevada Rules of Appellate Procedure and even Rule 60 C1 require a timely motion under the honeycut procedure.
Okay, and what does it say? Tell me what it says.
60 C1 under timing. A motion under Rule 60B must be made within a reasonable time and for reasons 1, 2, and 3, no more than 6 months after the date of the proceeding or the date of service of written notice of entry of the judgment or order, whichever date is later.
Well, I understand that, but isn't this a Rule 62B? I'm sorry, 62.1 issue? What's the timing there?
I don't believe that rule addresses the timing other than to say it must be timely.
Because this is what the rule says, relief pending appeal. If a timely motion is made for the relief that the court lacks authority to grant because of an appeal that has been docketed and pending. To me, it appears those are the two conditions. Is this pending and docketed?
And a timely motion is made for relief that this court lacks authority to grant. And that
Right.
timely motion is their Rule 60 motion they're making today.
Wait, what does it say? If a timely motion is made for relief that the court lacks authority to grant, if it was a timely motion that was made for relief, I could grant it. Am I missing something?
You couldn't grant relief from judgment today because right now this court doesn't have jurisdiction.
Well, that's my point, and that's what the rule says. Right?
They made a motion for relief from judgment.
I'm not granting relief from judgment. You don't have to.
Correct. They're asking for an indicative ruling, right?
Well, that's an indicative ruling is not a relief from judgment.
Well, either way, their motion's got to be timely.
What's the time requirements for a Rule 62.1 motion?
It's got to be Rule 60, Rule 60
What does
C,
it
Your
say
Honor.
that?
Well, the title of their motion is
They're
motion for
wrong.
relief from judgment.
I'm not giving them relief from judgment. You don't have to argue that. I can't do that.
Okay.
You don't have to argue that. My thrust and focus is real simple. 62.1. That's all. I'm not, you don't have to argue relief from judgment. You don't have to waste your energy on
We
that.
don't think their motion's timely in any event.
Okay, I understand that. I get that.
And I think I've made my record on that.
Yeah. But continue on. You
Thank
don't have to worry about Rule 60. I'm not granting them any Rule 60 relief. I don't have jurisdiction to do that. That would be an instant reversal.
I understand that but I don't think you should tell the Nevada Supreme Court in an order that there's a substantial issue here because I don't think there is. They've talked about allegedly newly discovered evidence and they pointed to 2 emails and they pointed to 6 lines of testimony from a recent deposition. And with respect to the 2 emails, we put in evidence that shows NSF produced those emails about over a year and a half ago. So the emails are not new at all. These are the emails where Real Water is complaining about the auditors, that one was difficult to work with and the other had language problems and was being disrespectful and wanted different auditors assigned. The emails are not newly discovered. The testimony that they say is newly discovered evidence is Robin Forgy when she's asked, this is the Costco Director of Quality Assurance, and she's asked, well, she's asked a hypothetical, if Real Water was allowed to select its own auditors by NSF, would that violate a Costco policy? And she says, yes. But is that really new evidence or is that just a matter of common sense that a company being audited doesn't get to pick who audits it? I can't think of any regulated industry or situation where that would be permissible. So this doesn't seem like new evidence so much as a statement of the obvious. But
Here's my question for you, and you tell me, how should I look at this? And I mean, I understand we're going down a lot of rabbit holes, but it's a Rule 62.1 motion, right? And that's specifically what it is. And when I look at the rule, and I understand there's not a lot of case law on this, but it gives me three options. One would be defer considering the motion. Two, deny the motion, or three, state that it would grant the motion if the appellate court remands for the purpose or that the motion raises a substantial issue. And so when I'm looking at it through this lens, it appears to me maybe my thrust and focus should be simply this, that if the motion was in front of me regarding a motion to dismiss pursuant to 12b-5, would I have granted that motion potentially, or would I have denied that motion? Right? And that's kind of the thrust of my question. And I realize things have happened since then. Or potentially, would I have given an opportunity to amend?
Well,
Is that how I should look at this?
I think the rule is pretty straightforward. I think you can deny the motion. I think you can say in an order that it presents a substantial issue. Or you could say that you would grant the motion if the Nevada Supreme Court were to remand jurisdiction to you. I think those are the three things you can do. I think you've got to deny the motion under the law. I've talked about Malum, Wright, and PetSmart requiring control over the dangerous instrumentality as a requirement under the Good Samaritan doctrine. That was never alleged. With respect to amendment, the plaintiffs didn't seek to amend their complaint. In fact, they said no amendment was necessary. They didn't file a motion for leave to amend.
Well, then you're helping me out. You're saying, well, Judge, you shouldn't look at it through that lens because they didn't file a motion to amend or they didn't seek additional request from the trial court to say, look, Judge, can we amend and plead more facts? So what you're saying is, Judge, you should just look at the original pleading itself.
Well, I think you've got to look at Judge Johnson's order at this point because that's a final judgment.
Well, I'm going to tell, here's the thing. I don't mind saying it, saying this issue. And I've learned in the past, I remember as a younger judge, probably about 15, 16 years ago, I had a similar issue came up and I had questions regarding the prior decision, but it wasn't a honeycut issue. It was a motion for reconsideration, right? It was, which was timely, but the case had been transferred from me. I can't even remember the reason at all. And so I was looking at it through this lens and I said, well, I'm not a court of appeals. It was a motion for reconsideration timely filed and so on and so on. But I had my doubts, right? I had my doubts as to whether or not there was a proper basis in both law and fact for the relief that was granted. And so I said, no new facts, no new whatever under the rule. And it goes up on appeal, right? And when it comes down, who gets to reverse it? Not the prior judge. I learned a valuable lesson there. And I don't mind getting reversed, but I don't like getting reversed for someone else's decision making.
I can appreciate it, Your Honor.
That's what I'm sure. So I'm looking at that lens too.
I think perhaps the biggest point I wanted to make here is even if the court were to assume that the allegedly newly discovered evidence is new, there's 2 points there. One, it doesn't show that NSF actually allowed Real Water to pick and choose its auditors.
Now, what do you mean by that? I mean, speed real particular. I want to listen to it.
There isn't any evidence that shows NSF permitted Real Water to say, I want Sam Jones to be my auditor. That evidence doesn't exist. The second point I want to make is that even if we consider this new evidence, it goes to the wrong duty. It goes to whether NSF owes a duty to Real Water under its contract, and perhaps the Costco is a third-party beneficiary. It doesn't go to whether NSF owed Daisy Way a duty under tort law and the Good Samaritan doctrine. And that's why this new evidence is completely irrelevant here.
So,
And if they want to talk about Good Samaritan doctrine and they want to argue that NSF somehow increased the risk of injury, I still think that at a minimum they would have to show, or they would have to allege that Real Water and Costco relied solely or substantially on passing audit scores. But we don't have that allegation either. The real problem here, Your Honor, is just a failure to allege facts that would show a legally sufficient claim. That's why Judge Johnson granted her motion, and that's why you should deny the present one. Finally, a word about prejudice to NSF. NSF hasn't been participating in this case for several months. It has participated in discovery in other cases, but NSF's counsel, they weren't even at the deposition of this Robin Forgy that the plaintiff is citing in their motion. So we've already suffered a bit of prejudice as far as that's concerned. We're about 2 months away from trial, as I understand it, and it would be prejudicial to NSF to have to try and prepare summary judgment motions in limine, and prepare for trial in the very short 2 months it's got. You know, for example, I don't know if NSF would be allowed to rely on its prior expert reports. Would NSF be allowed to take Ms. Forgy's deposition at this point? We don't know. And in the absence of knowing, it certainly appears prejudicial. And
One last question on that. I mean, right now, NSF wouldn't go to trial anyway, right?
Excuse me?
They wouldn't be required to participate in the trial anyway.
That's correct. I mean, whether NSF a third party owed a duty under tort law to Ms. Way is an important question of public policy. Right now, it's before the Nevada Supreme Court, and the Nevada Supreme Court is in the best position to resolve that question and give further guidance to the lower courts. Unless Your Honor has any further questions, that's all I've got.
No, not at this time. Thank you, sir. What does Good Samaritan have to do with this case?
We allege the restatement that this court cited and had actually just read, sorry. I got all these papers here. And that this is the exact reason why we have said.
This isn't really a Good Samaritan case, right?
So we cited that under the restatement, and it's on page 13 of our motion, is the restatement second of torts 324A sets forth the rule for the negligent undertaking. And we cite the rule just as Your Honor read. And it
But that's
says,
different that's much different than a Good Samaritan, right?
yeah, and that's what we said is 324A, that looking at this negligent undertaking is, you know, it's
Voluntary undertaking.
exactly. And, you know, if there's the failure to exercise reasonable care, the undertaken to perform a duty, you know, the harm is suffered because of reliance. And that's what, you know, and I appreciate Mr. Fountain suggesting that this isn't a new fact or anything like this. The emails just in of itself, we didn't really have the connection there. This is a deposition from a Costco person saying, you're not allowed to pick your own auditor. The emails say, as soon as they get a failing audit, they write to NSF saying, complaining. Then magically about 2 months later, they rose about 20 points in their next audit. And so those at least are the facts. Obviously, you heard Mr. Fountain say a numerous amount of facts, and that's our point. Is this was dismissed on a 12B5 motion, is there was a number of facts that plaintiffs now have learned and or could have pled but weren't provided the opportunity to. So what plaintiffs are requesting is, especially in light of this deposition with Robin Fogy, and basically connecting the duty, the breach, and the causation all together, is that plaintiffs at least should be able to have the opportunity to try this claim. What happens, and this is the practical effect.
Which exhibit is the complaint?
The complaint?
Yes. Was the complaint? I don't remember seeing it.
I'm not sure you're on.
Say motions to dismiss. It would have been an amended complaint, right?
Correct, Your Honor. It looks. I don't see it as part of the exhibits.
Before I make a decision, I'm gonna read the complaint. I don't remember. You don't have to provide a copy. We can burn a copy of the complaint.
And just a couple of
But I'll read it before I make a decision.
And just a couple of other points, Your Honor, it's as I mentioned in the beginning of this is NSF moved to file,
The amended. So the amended complaint, right?
correct, Your Honor. Which is adds NSF as a party. So we moved to amend NSF as a party, and we did so in all 5 cases of the real water cases we have. 4 of the judges denied NSF's motions to dismiss, and now those claims have settled. But now we have this 5th one here. And so Judge Johnson granted the motion to dismiss without leave to amend, and I like to correct
Mind
that.
telling everyone, and it'd be really fair to Judge Johnson, heck, I've known her since we were rookie lawyers in ends of court together. So I'm not concerned about necessarily whether 4 ruled one way and she ruled another. I've known her for a long time. You know, and I
Correct.
respect her.
Yes, and that's what we're saying here in part is we didn't have the deposition of Robert Foji. We didn't have all these pieces to kind of put together in order for Judge Johnson to say, hey, we've, have.
I think that was 1986, ends of court first. But go ahead.
And I won't tell Your Honor that I wasn't born yet then. Just kidding.
That should
Berlin
be-
Wall is still around now.
Yes, it was. It was.
But I think that really this whole argument and NSF's whole argument emphasizes plaintiff's point is Daisy Wee's complaint and all of her claims are going forward before this judge in October. So there's 2 months left of the discovery period. Trial's not until October, just to make sure. I don't know if Mr. Fountain.
This isn't the
understood
one
that.
set in front of me. This isn't is this the same case?
Correct.
But I
So
mean, this.
Daisy Wee is in one of the consolidated cases, Your Honor.
Okay.
So this trial is set currently right now for Daisy Wee's claims are set to go before Your Honor on October 7th. And really what happens, the practical effect of this is if her claim, especially now that we have these new facts, is held up at the Nevada Supreme Court for months, years, however long it is, we try the rest of Daisy Wee's claims in front of Your Honor in October. We go through the expense and the judicial resources and all of the time that it takes, and Your Honor knows, as you've done with the real water cases, of what that means. Then, after what plaintiffs believe is a getting the claims back here in front of Your Honor after the Supreme Court determines that there is sufficient facts, we have to try all those claims again. So we have to bring in all of the experts. We have to try another real water case just to solve the claims that NSF has. And that's kind of the reason why we're here. We're here to say, Your Honor, there are more facts than what we had to even plead in the complaint. We would like to amend and bring those complaints and seek relief from that 12B5 order of dismissal. And what we're asking Your Honor to do is just saying that there seems to be a substantial issue under 62, is there seems to be something in order to give this court the opportunity to hear that 60B motion, in order to have everything flushed out, in order to see if we can try these claims in October. Because otherwise, well, one, we might as well throw it out the door. There's no just, speedy, or inexpensive way for our plaintiff to move forward on these claims against NSF absent this request, especially in light of everything that we've learned.
As far as NSF is concerned, ma'am, can you tell me, as far as the amended complaints concerned, what page should I look at?
I believe it's the 9th cause of action. If as far as the cause of action goes, I believe, if memory serves correct, Your Honor.
Your Honor, if I could just jump in, I'm looking at page 4 to the exhibits to our motion.
Yes.
It's the Judge Johnson's order. It says our amended complaint was filed March 7th, 2023, and Ms. Switzler is right. It's the 9th cause of action related to NSF.
Your Honor, I can tell you which paragraphs if you like.
Oh, yeah, absolutely. I just want to make sure I have the right one because I'm looking right now. And when was the amended complaint filed again?
March 7th, 2023.
So a year before we had this deposition testimony.
And it says it's document number 115.
Is that the second amended complaint or something like that?
It says just amended complaint.
It's
I
March
checked it.
7th of 2023, if that helps. On the filing date. And it's doc number 115, if that also helps.
That probably helps more than anything.
I know sometimes these cases have long doc numbers too, so.
Document 115 is a summons.
Oh, well, that would be fun for us.
Well, it might be because it's in a separate case number A22856-147B.
856 what?
147B.
I'm glad I asked this question because
And that's Daisy Wee case, and it was in front of Judge Johnson. Here, if that helps.
Computer is slower than I would like.
But sir, you were saying which claim for relief should I look at? And what
It's
page?
the ninth cause of action, Your Honor. It's paragraph 25 and paragraphs 204 through 208.
Paragraph 25 and 204 through 208.
And I think the whole ninth cause of actions lays everything out there, Your Honor.
It's pretty.
Well, go ahead. I didn't want to cut you off.
And just quickly for the record, Your Honor, as far as the timely issue goes, we believe that it's timely. Under, if you look at Rule 60, as Mr. Fountain suggests, is because if you look at the rule, it says a reasonable time under, if we're seeking relief under 60B6, and that's what we're doing here. We're not
So
necessarily
where
under,
are you at again? I just want to make sure I can follow you.
60B6. Well, it's 60BC1 is the timing, Your Honor.
And you said 60B.
C1 is the timing
Okay.
requirement, but it's kind of involves the whole rule. So it says a rule under 60B must be made within a reasonable time. And for reasons 1, 2, and 3, no more than 6 months after the date or proceeding of the date of service of the written notice of entry, judgment of order, whatever date is later. And Rule 60B, if you look, and it says, the on motion for a final judgment, order, or proceeding. So the order was not final until December when 54B certification rendered it a final order. And so whether you say a reasonable time or within the 6 months, this motion was filed. And it doesn't fit squarely under B2 because that says newly discovered evidence that has been discovered in time to move for a new trial under 59B. We're not moving for a new trial under 59B. We've never had a trial. We just want to be able to plead our claims. And that's the basis for our 60B relief request.
I'm still trying to decide why 59 or 60 would still have any relationship to 62.1, which is a separate rule. Is there a reference made in Rule 60 as made to 62.1?
And as far as it relates to 60, yeah, the reason why 60B is a little bit involved in here is because if you look at 62.1A3, which
Why don't
is,
we look at the advisory comments to the rules? Right? Do you guys still use books or not?
I do have one in my office.
Well, but I mean, it says here, it says, quote, and this is the advisory committee note 2019 amendment. It says this new rule is modeled on SFR CP 62.1 and works in conjunction with new rule NRAP 12A. Like the federal counterpart, Rule 62.1 does not attempt to define the circumstances in which a pending appeal limits or defeats the district court's authority to act. That's the rule. That's what the advisory committee notes say. I don't know why no one picked up on that, but this is really important. It says, and it says CFR CP 62.1 advisory committee note 2009 amendment. Rather, these rules provide the procedure to follow when a party seeks relief in a district court from an order or judgment that the district court has lost jurisdiction over due to a pending appeal. And it seems like to me, potentially from a timeliness perspective, we have the issue focuses on whether I have jurisdiction, I don't, and whether there's an appeal or not pending.
Correct. And as far as that, we just, in order, and if you look at NRAP,
Site honeycut versus honeycut.
yes, and that kind of involves NRAP 12A as well, which has very similar language as 62.1, which says the district court, we can request for remand from the Nevada Supreme Court as long as the district court states that either it would grant the motion or that it would raise a substantial issue. And that's why we're requesting relief
Did
here.
anybody take a look at Moore's Federal Practice and Procedure, or Wright Miller, as it relates to this specific issue?
I'm not sure.
Your Honor, I thought it was pretty clear cut that the motion is untimely.
Well, I mean, I don't know. I mean, I'm looking here, it just says. It says right here, it says. Rule 62.1 does not attempt to define the circumstances in which a pending appeal limits or defeats the district court's authority to act under the specific rule. It's straight out of the advisory committee notes, right? And the reason I'm bringing this up, I mean, and we can get far afield, we can talk about Rule 59, Rule 60, and that's a whole set of different facts. When it comes to the specific limited relief requested under this specific rule, I'm not convinced that I should even consider those types of analysis.
And Your Honor, we just are seeking relief to at least get this issue before you and to get jurisdiction.
No, I understand what it is, but I don't mind saying it. I'm focusing on what rules. It's a new rule. That's what the advisory committee note says.
Yes, and Your Honor, you understand that the 60 rule motion that you don't necessarily want to rule on that today, and I understand.
I can't rule on that.
Yes, and so what we're asking is
If
for
I
an
ruled on that,
indicative ruling.
if I ruled on that, I think there'd be a problem.
We're
I'm not gonna do
asking-
anything where there's a problem.
Correct, and I completely understand that. And so what we're asking for is for you to indicate in one way that there's a substantial issue to let the Supreme Court know that and give you back jurisdiction in order to rule on the 60B motion. And that's why we're asking here is we're saying, look, there's enough grounds here between the new facts, Rule 60, failure to plead, all these issues here in order to let the Supreme Court know that, hey, there's a substantial issue here. Plaintiff Daisy Wee is going to face a lot of prejudice in this. There's a lot of issues. 12B5 pleading standards are so low, and the fact that it was dismissed, we now have all these other facts that even NSF has been, saying in front of you as well, that gives rise to a claim. And so what we're seeking is to have you indicate that there's a substantial issue in order for the Nevada Supreme Court to make the decision to remand it back to you so that we can have these issues before you. And so that we don't have to go forward in October without having these claims and wait years in order to have this exact same claim and have to do another real water trial once it gets remanded back to you from in the future, whenever that the Nevada Supreme Court grants our appeal, Your Honor.
And I just want to make sure I'm clear. Paragraphs 25, paragraphs 204 through 208.
Yes, Your Honor.
And we would just say the whole ninth cause of action. I don't have the complaint in front of me. So between
I've written that down too.
Yeah.
I mean, I'm looking here and for the record, that helped me a lot, but because we have a 33 page complaint. And I want to make sure that I focus on what's important. Anything else?
Just as far as the timing, Your Honor, is obviously in order with the trial coming up, in order to get a ruling.
There'll be a 48-hour turnaround. So I understand.
We just
Time
wanted
differences.
to remand it and ask the Nevada Supreme Court to remand it depending on your ruling, Your Honor.
All right. Anything else from anybody?
Your Honor, just real quick. Plaintiffs' counsel made a reference to Rule 60B6 a moment ago. To the extent they're seeking relief under Rule 60B6, we've argued in our papers, they're not entitled to it.
I'm not doing any of that.
That's all I have to say.
Yeah, I'm not, sir, you don't even have to argue Rule 60 to me. I'm not touching Rule 60.
Thank you, Your Honor.
Yeah, I'm just looking at 62.1. That nothing more, nothing less. Okay, and we'll get this. I understand times of the essence. Everyone enjoy your day.
Thank you, Your Honor.
Thank you, Your Honor.